General provisions or general rules. General provisions or can also say the general rules. Both are same. General provisions or the general rules of succession under Hindu Succession Act 1956 is now going to present. What are the general rules and what are the general provisions you will find under the Hindu Succession Act? The general provisions are dealt under sections 18 to 23 and section 29. What are the sections? Section 18 speaks about the full blood. What is the full blood says by the section 18? Mode of succession, when there are two or more heirs, was dealt under section 19. Section 20 speaks about the rights of the child in the womb. Section 21 laid down a presumption in case of simultaneous death. Section 22 deals with the preferential right to acquire property in certain cases. Section 23 deals with the succession to the dwelling house. And the last section 29 deals with where there are no heirs or absence of heirs, who are going to take that property. So these are the general rules or the provisions of Hindu Succession Act dealt under section 18 to 23 and 29. Now we will have a discussion one by one. First is the section 18, which says about full blood. So this section says that the heirs that are related to the intestate by full blood shall be preferred to the heirs related to the intestate by half blood if the nature of the relationship is the same in every other respect. So this is a condition. What is the condition? The relationship must be same in every other respect. The nature of the relationship must be same. What is that? We'll see later. Before analyzing this section 18, section 3 says, if the two persons are related, for example, you take A and B. The two persons are said to related each other by full blood if they are descended from the common ancestor by the same wife. And further section 3 says, if the two persons are said to related each other by half blood, if they are descended from the common ancestor but by different wives. This is the verbatim of section 3. We will put it in a very simple words. You take A and B. Both are brothers. We call the brothers by full blood when their parents are the same. Father and mother is the same. Then the relation between A and B are the brothers by full blood. Suppose if father is the same to the A and B, but mothers are different, then the relation between the A and B is said to be half blood. Suppose the mother is the same to the A and B, mother is same to the A and B, but fathers are different, then the relation between A and B is by uterine blood. And this section 18 says full blood shall be preferred to the half blood. But what is the condition? If the nature of the relationship is the same in every other respect. If the relation between the A and B, the relation between the A and B, the nature of the relationship between the A and B is the same in every other respect, then full blood shall be preferred. I will give an example. The deceased or intestate, both are same, don't get confused. Deceased or intestate has a full sister and half brother. There are only two heirs. One is a full sister and the other is half brother. Nature of the relationship is same. Both are on the same degree. Sister and brother, same degree. Nature of the relationship is the same. Then section 18 says preference will be given to the full blood. That is, the whole property will be taken by the full sister. The intestate or the deceased's property shall be taken by the full sister and half brother will get nothing. Suppose the intestate had or the deceased had sister's daughter and half brother's son. Here also the nature of the relationship is the same. Sister's son and brother's son both are on the same degree. Both are in the same degree. Then the full blood group will be given the preference. That is, the sister's daughter will take the whole property and half brother's son will not get anything. Suppose, for example, suppose I will say in another way, the deceased had a full sister's daughter and it is only the half brother. Full sister's daughter, one heir, and the other is half brother. Who are the heirs? Half brother and sister's daughter. The nature of the relationship is not the same. Here it is the half brother, here it is the sister's daughter. The nature of the relationship is not the same. So in such a situation, full blood group will not be given the preference. Half blood group will be taken. That is, the half brother will take the whole property and the sister's daughter will get nothing. So full blood group will be preferred only the nature of the relationship between the heirs or in the same in every respect. Every respect. Then only full blood group will be given the preference and half blood group will get nothing. If the nature of the relationship is not the same, then there is no preference to the full blood group and half blood group will take the whole property. And this rule is not restricted only to the brothers and sisters. That means if there is a full sister or full, it is not the male and female, whoever it may be. The question is whether they are full blood and half blood. Here it is the full sister and here is the half brother. But still there is no differences whether it is a male or female. What is required is full blood and half blood. So both sister and brother, or sister's son or brother's half blood group sons. Sister's son's son, half blood brother's son's son. So whatever it may be the nature of the degree. For example, I will say that deceased sister's son's daughter. So there are 5 generations. Here also the half blood group should have the 5 generations. That is half brother's son's daughter's daughter, whoever it may be. Whether they are male or female is not relevant. All are 5. Here is 5 degrees, here is 5 degrees. Nature of the relationship is the same. Then full blood group will take the whole property. So it extends not only to the brothers and sisters, their children, however remote. They are all entitled to take the property. And the next section, mode of succession if there are 2 or more heirs. Section 19 deals with the topic. If 2 or more heirs are succeed to the property of the intestate, that is these 2 or 3 heirs are eligible to succeed to the property of the intestate, save as otherwise expressly provided in this act, per capita and not per strips, as a tenants in common and not as joint tenants. This is the verbatim of section 19. If 2 or more heirs succeed to the property of the intestate, they shall take the property save as otherwise expressly provided in this act, per capita and not per strips, and as a tenants in common and not as a joint tenants. This section deals with the mode of succession if there are 2 or more heirs. So this is the first condition. Second, these 2 or more heirs together, they have to succeed to the property of the intestate. That is, all are eligible, all are qualified. They are entitled to take a share in the property of the intestate. That condition has to be fulfilled. Then the third condition says, they shall take the property except expressly provided otherwise. Suppose if there is any expression, so this section says that if there are two or more heirs, the property is to be divided according to the per capita and not per strips. Per capita means per head. Suppose if there is any express provision, so then the property is to be distributed not per capita but according to per strips. Again I am repeating. They shall take the property if there are two or more heirs according to per capita and not per strips. Suppose if there is an express provision says that the property is to be distributed according to per strips and not per capita, then according to the express provision, the property is to be distributed according to per strips. First, let us see how the property is distributed in per strips and how the property is distributed in per capita. That you can understand by looking into the next slide, that the per strips, this is also called as doctrine of representation. That is, the children are representing on behalf of the father. They are doctrine of representation. They are representing their father. They are taking the father's share. Per strips means allotting a shares to the branches. So here the deceased had son and daughter. Son and daughter. This son had two sons and two daughters, that is S, S1, D and D1. The daughter had two sons and one daughter, that is S, S1 and daughter. These are all class 1 heirs. According to section 10 of the subsection 3 and 4 of the Hindu Succession Act, there was an express provision. The express provision says that the property is to be distributed according to per strips. So here the property is to be distributed according to per strips because there was an express provision. There was an express provision. So the property is to be first divided equally between the predeceased son and predeceased daughter. So each will get half half. S will get half, D will get half. And this S had two sons and two daughters. This half is to be divided equally to all these heirs. That is 4 equal parts is to be made. So 1 by 2 into 1 by 4, each will get 1 by 8. The daughter's share, half share, is to be equally divided between the two sons and daughter, that is there are 3 heirs. So half into 1 by 3, that is 1 by 6 each will get. So this, how this per strips applied in this case, because there was express provision. There was an express provision under section 10 and clause 3. So wherever what this is, section 19 says, whenever there is an express provision, according to the express provision, the property is to be distributed according to per strips. That is doctrine of representation. Even if you look into the female heirs property, the subsection 1 of section 15, where there are sons, grandchildren and husband, the mode of distribution of the property is per strips, because there was express provision. There was an express provision. So the property is to be distributed if anywhere, wherever there was an express provision and says the property is to be distributed according to per strips, then property is to be distributed per strips. Now what is the per capita? Per capita means per head. So here the deceased had 2 sons, S and S1. S had a daughter and S1 also had a daughter. and son's daughter had 2 sons and 1 daughter, and S1 daughter had only 1 heir, that is the son. What is the mode of distribution according to class? These all falls under the class 2. Class 2, entry 2 of class 2 heirs. Entry 2 of class, there are no class 1 heirs, all are class 2 heirs. So they are eligible to take the property of the intestate. They are entitled to take the, but there was no express provision regarding the distribution of the property to the class 2 heirs by saying per surface. There was no express provision. So section 19 says, in the absence of such express provision, if there are 2 or more heirs, the property is to be distributed according to per capita, that is per head. That is, the property of the deceased is to be divided into equally 4 parts. The property is to be divided equally into 4 parts. So even though S1 daughter has only 1 heir and S daughter had 3 heirs, all will get equally, because there was no express provision. Section 9 says that all the heirs who are within the entry, they will take simultaneously and equally. That's what the law says. So all will get 1 by 4, 1 by 4, 1 by 4 and 1 by 4. This is called per capita. So section 19 says that in the absence of express provision, when there are 2 or more heirs, the property is to be distributed according to per capita. And if there was an express provision, says that property is to be distributed according to per strips, per branches, then property is to be distributed according to branches. Next, what is a tenancy in common and joint tenants? So here none of the owners may claim it, that is tenancy in common. First we will see tenancy in common. Here none of the owners may claim any specific property. They will not get equal share. They will not take the share at the same time. They will take the different times. For example, if there are A, B, C, B and C may get 25%, A may get 50%. So if there is no specific area of the property, there is no equal share, they won't take in the same time, they will take the different times. It is called as tenancy in common. What is joint tenancy? All the heirs will take equal shares at the same time in the same deed. Take the equal share at the same time in the same deed. That is called as joint tenancy. But there is no joint tenancy between the co-heirs under Hindu Succession Act 1956. So here we will follow the tenants in common, because there are different heirs, they will get the different shares at the different times. There is no specific area of the property. So tenancy in common is applicable under Hindu Succession Act. This is a mode of succession when there are 2 or more heirs under section 19.